Thank you for joining us on the Ask Canada's first face streaming Family Law and Answer show. My Feldstein and I'm the founder of a family law firm, Family Law Group. Both the entire team practicing in the area of family. Today I'm joined defense lawyer Sheldon. Welcome to the show, Sheldon. Thanks for having me. Now,
Andrew?
You're welcome. Now I'm going to say a little background. I've probably known Sheldon, I'm going to guess 15, 20 years. The years start to merge together, but I always remember that when a friend of mine who I sent all my criminal work was appointed to the bench as a judge, and I said to him, "Now who do I send my work to?" He gave me Sheldon's name, and Sheldon's never disappointed since then when I've referred him work. So I hold Sheldon's work in high regard. So today we're going to talk about the intersection of criminal and family law. And it can be difficult for clients to navigate their legal matters when different fields intersect. Today we have Sheldon, and we're going to attempt to have a discussion about how clients can navigate their legal matters which touch upon both criminal and family law issues. So Sheldon, can you start by telling us a little bit about your work as a criminal defense lawyer?
So I started practicing in 1986, and I've been doing criminal law exclusively since about 1998. Most people think criminal law is about the murders and rapes that you read about in the newspaper, but fortunately, we live in a pretty safe city, and about a quarter of the no, about a third of what happens in our criminal courts are really family law matters or that are have sort of expanded to the criminal world. By that I mean quite often you have people who are not getting what they want in family court, such as trying to get the other party out of the house, and then run to a police station and say he assaulted me, she pushed me, it happened 5 years ago, and due to the politics behind the situation, the police are duty bound to act, and they don't really have much discretion in what to do in terms of, do I believe this person, even though I know it's a complaint from 14 years ago, or do I go ahead with it? So they invariably will go ahead with an investigation, which leads to an arrest. And unfortunately, what happens is that the person who has been unsuccessful in family court in getting an exclusive possession order suddenly gets the balance of power in criminal court because charges are laid against the other party. And as a result of those charges being laid, standard bail conditions are you're not allowed to go to the home, you're not allowed to um, cohabit, you're not allowed to have any communication except through a lawyer or a third party. So there is a lot of overlap between criminal and family law.
So I think Sheldon, what you're really talking about is in family law, and you mentioned some words that I'm not sure our viewers may appreciate. You talked about a concept called exclusive possession. And most people are aware of the concept of there's a matrimonial home. That's where the family lives in as a family unit, and they occupy that on a day-to-day basis. And I'll frequently have clients come into my office and say, well, I want him out. I want her out of the house. And I let them know that from a family law perspective, it's a fairly high threshold in order to get that order for exclusive possession. And it's not inexpensive. When they pay me, they're going to spend a lot of money paying me to go get that order for an exclusive possession. And in fact, if it's not urgent, we have to have a case conference first. So I'm telling them they may not get their motion heard for exclusive possession for 6 to 8 months, and they're going to spend a fair bit. And whether they hear about it through friends or they read about it on the internet, they can also learn that if they, as you say, make the historical claim to the police that they were assaulted, their spouse will be removed from the home and have all of the consequences that you said. And the person who made those allegations initially has two advantages. Number one, their spouse is removed. Number two, they didn't have to pay to remove their spouse. So they got speed and savings of money. Now, this isn't to diminish domestic violence, or as the Divorce Act calls it, family violence. Those things are entirely relevant, they're important, and they need to be treated very seriously by the police when it does happen. The hard part for any lawyer is we hear two sides of the story. One day we act for the victim, the next day we may act for the person who is the accused. And we have to advocate the best that we can as a family law counsel for both sides. And Sheldon comes from the side of acting for the accused in court and seeing how those allegations from 10 or 15 years may impact family law. Because the question I would have for you, Sheldon, and I think our viewers would be interested, is how often does the Crown get a conviction on these historical allegations that are more than, say, 5 years old?
It happens more often than you would think. It really does. And people think there's, we're all used to watching TV. They think there's some DNA evidence, there's some great, microscopic fiber that's going to shed light, or there's medical records. But invariably, and in my experience, it really turns down to a credibility question. And let's call it the stereotypical complainant is a woman, because that's the way the world is, unfortunately. And if she appears as credible and consistent in her story to the police, to the Crown Attorney when she's interviewed by Victim Services and later by the Crown Attorney, then ultimately it's, the Crown is going to be successful in their pursuit of this case. Now, often these types of cases are resolved before they go to trial. If it's a non-violent situation, these days often there's a diversion such as the PARS program, which is partner abuse, or the party could be sent to a private counselor, could be sent to the government-run partner abuse program. They do a report, they do some upfront counseling, and they come back. Their lawyer meets with the Crown Attorney who's prosecuting the case, shows them that they've made great progress in where they're at, and then, quite often these things are resolved without ever having to go to a trial, sometimes even resolved without the offending party being left with a criminal record. The problem, though, is that because this is used as a tool by people who are unsuccessful in family court, often the real complainants, the real victims in domestic violence, are lost in the shuffle because so much energy is wasted following up on this. Now, I know this both as a defense lawyer and having worked in the Crown Attorney's office as a part-time Crown Attorney for over 15 years. The domestic violence is a real issue. It's a live issue. And when you have a complainant who's made something up to say he pushed me, he shoved me, and then we're wasting valuable police resources, we're wasting valuable court time, prosecutorial resources on cases that really shouldn't be there. And that's a bit of a problem for the system and for justice for all, because on top of everything else, everybody wants to have a speedy trial. The person who was arrested and accused last week, if he were to go to trial, if he denied it ever happened, is not willing to resolve it, and wants to set a trial date, he's looking at 8 to 10 months at a minimum for a trial date. And in the meantime, he's out of the house. He's not seeing his children on a regular basis. The balance of power has suddenly shifted, and it's a difficult situation.
Now, one of the things that the amendments to the Divorce Act did brought into play family violence. Now, it was always there, but they've explicitly come out and said it, so that family violence plays a role in the determination of decision-making and the contact between one parent and the child. And in fact, even if you're found not guilty in a criminal court, from a family court perspective, that's not the end of the discussion, because a criminal court is proof beyond a reasonable doubt. And a family court's evidence is balance of probabilities, which means 50.1%. So it's obviously a good start for someone to be found not guilty in a criminal court, because, Sheldon, you can correct me if I'm wrong, but I don't think it's very often that a criminal court goes beyond a finding of not guilty with respect to an accused.
No, they do not go beyond a finding of not guilty. That's sort of a TV concept where the judge is going to be admonishing the other side. I'm going to take your example one step further, and it's a case that I've just completed within the past 2 weeks. So this is a child protection case where the couple was married. There were 4 kids together. There was an allegation made by one of the kids to a teacher that he had been assaulted by his mom, that his mom had pushed him. The teacher did what they're supposed to do. contacted Children's Aid, contacted police. There was an investigation. The mother was charged. The couple broke up. And until the matter actually came to a trial, because of the nature of the allegations, it took 2 years. And in the meantime, because Children's Aid was involved, they curtailed the mom's visitation. It went from having the child living with their children to having supervised visits. And because of COVID, because it started during the COVID era, those supervised visits suddenly were no longer in an office. Now they're on a screen, like we're talking on a screen. 2 years later, being actually 2 weeks ago, the Crown Attorney decided that there's no longer in the public interest to proceed after me basically pushing the same agenda I'd been pushing for 2 years, saying there's no evidence of any of this, and there's a hidden subtext between husband and wife, and a kid was involved as almost as a patsy. The charges are withdrawn, and she's been completely exonerated. However, she's been stuck through the system for 2 years. In those 2 years, you as a family lawyer could say there is a new status quo, term I remember from law school. And unfortunately, in this case, the lawyer for the the Children's Aid Society is taking the position that so what that the charges were dropped in criminal court. We still think there's something to it, and we're not changing our position at all. So now this poor woman has to go back to family court to ultimately is going to have a trial to try to reassert that she's innocent, that nothing happened. So this is kind of the worst abuses of the system that can happen.
And that's a very sad story as well. We have to remember these children have been denied 2 years of time with their mother. And
Right.
we talk about the status quo, but here we have a status quo where the person who sounds like used the child from your description as a patsy has now had 2 more years to bond with the child, and mom in a supervised parenting setting is going to face a very uphill challenge that by the time she concludes the family court matter, what's her relationship going to be like with the children? I often remember the first case I ever had that dealt with parental alienation, going a little off topic right now. But it took me about 2 years to get my client parenting time with his child through court orders and fighting. He spent a small bucket load of money, and I remember how excited he was. And the child walked into his house, who he hadn't seen in 2 years, went to the bathroom, left his business in the toilet and didn't flush, then went into the family room, turned the TV up to maximum volume, ignored what the father had to say, who had remarried. And you just have to say common sense is, how long is the father going to be able to deal with this? How long is the newer wife going to be able to deal with this child who's completely out of control? So when you don't get in front of this kind of thing early enough, whether the allegations were founded in truth or not, it can be very, very difficult to ever walk it back from where you're at. And it certainly will be extraordinarily expensive. And it's a sad, sad statement that we as lawyers or the court system is unable to weed out what should be there. I mean, there's some cases of domestic violence that are so obvious, you just know it. And then there's other cases, like you say, where it's historical reporting. We're not there. We don't know what happened. And it has significant consequences, not just on the accused, but on the children as well, which is really a sad statement. And one of the other hard things that people don't realize between a family court and criminal intersection is you as a criminal lawyer, Sheldon, you get something called Crown disclosure, right, about the case.
Right.
But if I'm acting as the family law lawyer and you're doing the Crown disclosure, I'm not entitled to see what the wife has said to you in that said to the police in the Crown disclosure to see if it's inconsistent with my case.
It's actually worse than that, Andrew, because in order for me, so the Supreme Court of Canada says that every person accused of a crime is entitled to see all the evidence against him or her, meaning video statements, surveillance video, officers' notes, written statements, pictures, anything, medical reports. But me as a defense lawyer, I have to sign an undertaking that I am not going to disclose that with anybody else other than my client. And of course, you're going to need that if it's a situation where There's a lot of lies, a lot of innuendo, things that evidence that you could use. The only way you're going to be able to do that is if you have to bring what's called a WAG application. You have to bring a separate proceeding, go in front of a judge, ask for a court order to release this. Those applications are time consuming. They're very expensive to the client. In my view, it's almost like an abuse of the system, and it's unfortunate that what you would want to know as the easy truth, that I'm not allowed to walk it down the proverbial corridor to you to give it to you. It's forcing you to go through hoops.
And the absurdity of it is that you can give it to your client.
The absurdity is I can give some of it to my client. I can give the notes to my client, but I'm not actually, if there's an interview and the interview is recorded, I am not allowed to hand my client a copy of that recording. I'm not allowed to even email it to him or her. If they want to watch that recording of that interview of the other party or their own interview, they have to come to my office or the Crown Attorney's office to watch it, which in my view is it really puts the accused person on the defensive, and it doesn't set up a fair playing field.
So part of the absurdity is my family law client will say to me, well, this is totally inconsistent with the Crown disclosure. And I can say, well, that's nice. I don't get to see it without bringing the WAG application you just discussed. So it creates this large impediment to the accused being able to see all the information and use it in the right place. I mean, the best we as family law lawyers can do, and there's a charge for this, is for somebody like me to say to Sheldon, here's the court material in the family law application, you read it. And if you think it's a good idea to bring the WAG application, then bring it. Because that way you're not telling me anything that I shouldn't know, but you can make that call for me of understanding whether you, as a seasoned litigator in criminal law, can appreciate that that would probably be helpful to me. So that in of itself creates these additional costs. So one of the problems that I think Sheldon overall is talking about is that the person who is the accused, and in some cases, believe me, they deserve it, and in other cases, it's not so straightforward. In those cases, they're paying a criminal lawyer, they're paying a family law lawyer, and now they have to pay someone to bring this WAG application. Their legal fees are extraordinary and much higher because they have so many different legal issues going on. And they're not necessarily focused on fixing what needs to be fixed, which is a family dynamic that's going to help the kids see both of the children and help the family move on because of this new artificial reality. And one of the problems we get as family law lawyers is we get the client, and as I said before, I have both clients. So when you act for the person who is the victim, they de facto have the home, they de facto have the children in their care, and the other side's lawyer is asking for some parenting time. And they're the ones facing the uphill battle. And that becomes very hard, especially if they don't have a place to go that will allow them to even have their children for overnights, because sometimes that happens too. They have a large mortgage, they don't have parents or family. So we see all of these sort of challenges that people take on as a result of these charges that have real implications to what's going to happen to the family going forward. And the problem is the justice system just simply is not fast enough to accommodate what families need, i.e. an adjudication of the criminal matter so that we know whether the court has viewed this person as having been violent, having done a crime or not. And from a family court perspective, we're also going to be moving ever so slow, which then leaves that person in a situation. Sometimes we bring urgent motions to say the other side isn't granting any parenting time and we need to have parenting time. But part of it's going to be, where do they get to live? So picture if somebody lives in York region and the only place they can get to live in is their parents, and their parents live, I'll give an example, at Bayview and Eglinton, and now it's a 1 hour drive to where they used to live during rush hour. Guess what? Even if I do get them parenting time, now, it's not going to be equal time because it's not going to work. You're not going to pull the child out of school. You know you're not going to get midweek overnight parenting time because it's too far of a commute for the children in the morning. So most likely the best you're getting is alternating weekends, Friday to Sunday, because the child shouldn't have to have that long drive to school in the morning. And what you're going to get is maybe a few hours during the week of really artificial parenting time where maybe you get to pick your child up after school, take them to an activity, providing your former spouse isn't at the activity because of the terms of your release, and then taking them out for dinner. And you have to have, when there's that midweek parenting visit, you're also going to have to coordinate around the court order in terms of your restrictions of how you're going to do the exchange. Is it going to be through a third party? Or are you going to have an exception that's going to allow you to drop the children off in front of the house but not get out of the car, which is rare but sometimes happens. All of these create very, very difficult dynamics to ensure that the children are getting the benefit of both parents. And I say that uh, on the understanding that family violence does happen and it's something very serious that should be taken seriously. But when the court feels that both parents should be seeing the children, that's something to be encouraged, providing the children are safe. So, from your perspective as a criminal lawyer, Sheldon, I'm curious to know when you're acting for the victim, because that's what you know, how stressed and aggravated do you see them by the process that they're not having the kind of relationship that they had with their children prior to the criminal charges?
That's a great point, Andrew. That's a common theme. It's a constant theme because the wheels of justice move very, very slowly. And a person gets arrested or charged, uh, and one of the standard bail conditions, not attend at the family home, no contact except through a third party or through a lawyer. Suddenly they're evicted from their home. If they ran a home business, they've got to find a new place to set up. Seeing the kids, sometimes there's a mission, sometimes it's a meal at a mall, sometimes it's as you said, going to an activity. The entire balance of power is shifted, and the people that I represent are usually stressed beyond belief because they want this case over and done with faster so they can go back to their previous lives. I, as a lawyer, have to tell them that actually, contrary to everything you think and every instinct you have, time is really on your side because with the passage of time, you can show that you are not this dangerous person. You can do some upfront volunteer work or counseling or whatever to prove to the Crown Attorney that, hey, this is nonsense. And if, okay, you guys had an argument that maybe got out of hand and somebody pushed somebody. In one case, somebody threw a baby bottle at another. One parent threw a baby bottle saying, it's your turn to feed the child. The other person threw the baby bottle back. The second, uh, the second catcher of the baby bottle ran to the police, and my client was charged with assault with a weapon, as strange as that may seem. And 2 days later, when cooler heads prevailed, the woman was at the police station trying to get the charges dropped, and the police said it's no longer our responsibility. The case was passed up to the Crown Attorney's office. Crown Attorney's office hadn't received the file yet. It was somewhere in limbo. 3 weeks later, when it finally arrived, well, now 3 weeks have gone by and a new reality has set in. You have two parents who are really stressed. You have a defendant or an accused who's out of his mind because with worry about what's going on with his kids. You have a complainant who's constantly contacting him saying, I need money, I need this, the kids need to see you. He's calling me saying, what do I do? And I'm saying, you're on bail, pal. You're not allowed to talk to her. You're not allowed to have anything to do with her. I feel your pain. I'm really sorry, but this is but if you do get caught having any contact with her, you will be charged with breaching the terms of your release. And even if I can get the original charges of assault dropped, the Poochie throwing a baby bottle, the penalty for breaching your bail is 30 days in jail typically. So there are real serious implications to criminal charges. And to circle back to what you said, my clients are generally not very happy about these sorts of things. Most of the time, they're wrongfully accused. I had one case last year, two very prominent people in in the GTA. Both have very, very responsible positions. Both earn a great deal of money. She was trying to gain some sort of edge in the property dispute. So she went to a police station, brought her, at the time, her 9-year-old daughter, who and she made the daughter say, "Oh, yeah, I heard daddy say, I'm going to punch your nose," to the police. Well, this is my client was arrested. He had to report his arrest to his professional association. Everything hinged on these, these allegations of a kid who was pushed into it. The family case is a mess. It's now 2 or 3 years later. It took 9 months for the charges to be dismissed, and that's only because I had a very brave Crown attorney who took a very serious interest in the case, watched the interviews of the mother and the child, had them re-interviewed, attended the re-interviewing of that mother and the child, and then spoke to the heads of her department and the heads of the local Crown Attorneys Association, the local court, to say, I think this is nonsense. I think it's going to be a travesty of justice. Meanwhile, it's hanging over his head for 8 months, 8 months in which he did not get to see that child, 8 months in which siblings did not get to see other siblings because some were living with him, some were living with her. Tens of thousands of dollars in legal fees to family lawyers and criminal lawyers. And it was awful, a complete travesty of justice. So from my point of view, I did my job and the charges were dropped, which is a rarity, getting charges dropped before having a trial in a domestic case that's high conflict. From his point of view, he says there is no justice and our country is a mess. And I think I'm living in China or Albania.
And the message I want to say to people as we get close to wrapping up the show is this: is domestic violence is a very serious thing. And like you said earlier, resources need to be allocated for the cases where there is domestic violence so it can be dealt with on a more timely basis. And the story you just described is sad. And people have to remember to love their children more than they hate their former spouse. It's a really simple concept. But had this lady loved her 9-year-old children and had she loved the other kids more, she wouldn't have got the 9-year-old child to make a false allegation, who now didn't get to see the father, didn't get to see the siblings, and has to then look. I get she's a child, but still has to look at her father and sit there with the guilt of knowing what she did. What are the ramifications for the mental health of this child going forward? How is she going to deal with that? There is so much damage that is created. Yes, we can litigate in a family court, but you need to be mindful of the moment you start to bring your child in, like this particular person did, what you are doing is you're providing your child with a curse. And in essence, the day the mother did that, she cursed all of her children. She did a lot of damage to the father, but she cursed all of the children because their relationships and their dynamics are all going to be messed up now. All the children are going to be concerned about relationships as they grow up, and think about what the message is that she's just taught her children. And I say to our viewers, don't engage in that kind of self-help when you think it may be a positive for you. You may think it's helpful for your case. But when you're doing these things and you're causing this havoc in your life for your former spouse, your kids are also seeing it. That should be reserved for those that deserve it, those that did it. It shouldn't be something that happens when it doesn't happen, because it messes up your kids. And there are so many people that have come into my office who I believe are victims of domestic violence and resist going to the police because they don't want to damage the relationship between the children and the other parent. And in some of those cases, it's completely misguided. But the point I'm trying to say is remember to love your kids more than you hate your former spouse. Sheldon, I want to say thank you for coming because I see that we are out of time. We hope our viewers have gotten to learn a few ideas about how to navigate matters between family law and criminal law, and how family law lawyers and criminal lawyers can assist their clients with these challenges. And thank you for joining us. If you're looking for any assistance as part of your separation or divorce matter, feel free to contact us. Take a look at our website, separation.ca. The next Ask Andrew show will be on Tuesday, April 30th at 12 o'clock. If you have any requests or ideas for the future shows, please email them to us at info@feldsteinfamilylaw.com. And thank you for watching.